Right. Welcome to our overview of Maine's Victim Compensation Program. Um, we are joined by Kelly McGillis, and we're just so thrilled to have her here today. So I'm just going to go over a couple administrative things before we get started and I introduce Kelly. So please feel free to drop some questions in the chat or unmute yourself and ask a question. We want to make sure that you all have the opportunity to engage with Kelly and get all of your thoughts and questions out there. If you're not speaking, please try to remember to mute. It just cuts down on the background noise and allows us all to concentrate a little bit better. So just please mute if you're not speaking. Like I said, the recording will be available on our YouTube channel, so you can come back and watch this anytime. And I'm going to drop any relevant documents that Kelly has given me, like the presentation slides and other informational documents, into the chat. Additionally, she's provided us with a survey to give her some feedback on the presentation. So if you could please take the opportunity at the end of this to look at the survey, fill it out, and send it her way when you're done with it. That would be great. So without further ado, I will introduce Kelly. So Kelly is the program manager for the Maine's Victims Compensation Program. She works to determine eligibility of victims of violent crime, and she reviews police reports, medical records, and more in order to make recommendations to the board in order to help victims receive compensation for out-of-pocket expenses. Though originally from Maine, Kelly lived in Seoul, South Korea for 2 years, working on a clinical trial for an improved smallpox vaccine, and as the vice president of Family Readiness Group, which welcomed new families to the country and assisted them with adjusting and learning to a new culture. She is passionate about working with vulnerable and victimized populations. Upon returning from South Korea, Kelly worked with Safe Voices, a domestic violence resource center covering Oxford, Franklin, and Androscoggin counties, as a liaison to the Child Protective Services there. She is also an advocate for civil rights, specifically including disability and the LGBTQ+ community. She has a bachelor's of science in human services and a minor in nonprofit administration. Kelly lives in Augusta with her husband and is an avid crafter who likes to paint, weave, and enjoys swimming and aspires to be a beach bum someday. I think we're all there. So thank you so much for being with us, Kelly, and I'm looking forward to your presentation.
Thank you. So I have a PowerPoint that I'm going to go ahead and share on the screen here, and that way we can go through that. Again, I couldn't find that big green button. There we go. All right, and again, if you have any, oh, I guess I can see you guys a little bit over here. If you have any questions or concerns as I'm going through, please do let me know. I can't see you, so please speak up or put in chat. So, okay, so I'm just going to start with the basic contact information for the program. We are housed in Augusta, behind the State House with the Office of the Attorney General. This is our mailing address as well as our generic phone number. So this is the one that's on the brochure that you can call at any point. We also you're welcome to call us directly. We each have individual lines. So if you're looking to speak to somebody specific, you're more than welcome to reach out to us. Currently, we have one person who is working completely remote, one person who is working completely in the building, and then I split my time between the two, depending on what is most needed for me or for my team. So email is the best way to get a hold of us at this point, but this phone number still goes directly to our contact numbers, and we will get a call if you want to reach out to us. We do have a website. It's through the maine.gov webpage under the AG's office. It's broken into the 2 sections, so you can either click on the Crime and Victims button, and that takes you to victims compensation, or you can also click on the forensic payments button, which is the payments for the sexual assault examinations. On this web page also is a PDF version of our application. So if you don't happen to have any physical applications, or you're wanting to perhaps email the application to somebody, it is on the website. You can download that as a PDF.
Hi, Ivy. This is
if
Kayla with AMHC. I got a call from a Natasha, I believe you spoke with. Okay. She mentioned you wanted to.
I think she was on a call that just unmuted.
Oh, I was so confused for a moment. So if you can't remember or can't find this particular web page, that's okay. Most of the time, I also just Google Maine Victims Compensation Program and it pulls the page right up. So that is particularly helpful. All right. So as I said, our program staff, we only have the 3 of us. I'm the director of the program. Again, I'm hybrid between in-office and remote. Kim Ward is our compensation specialist. She's been with the program for about 2.5 years. She's the primary contact for working with claimants and the court system and advocates, getting information and supporting the victims themselves. Alma has been with our program for it's like 11 or 12 years now. And she primarily works on the billing and the payments and vouchers, as well as the contact for the forensic examination billing as well. So you don't have to specifically call one or the other of us. You can call any of us if you need help. And we're all kind of doing it all at this point. So I'm going to go through this presentation. There's 2 parts to the program. And the first part is the application side of the program. And the second side is the forensic examination part of the program. I'm going to go through the application side first, and then we'll get to the examinations. And then basically both parts of the program, however, are intended to help with the financial burden that comes with being a victim of a violent crime. So that the person can actually focus on healing and not be saddled with a ton of debt that comes from medical or mental health needs, loss of work, all of that. So these are the 2 sections of the program. The application claims, this part of the program was implemented in Maine in 1993. Since then, we've had almost 5,800 claims processed and have paid out over $10.5 million in payments. The forensic examination side of the program wasn't implemented until 2000. And since then, we've done over 4,700 claims just for forensic payments, and that's been over $3 million in payments. So as you can see, in nearly half the time, or 2/3 of the time that the forensic program has been around, there's not a huge difference in the amount of claims that we've had. The forensic examinations is a really big part of what we do. And we usually have more applications for the forensic claims each year than we do for the actual application side. Some of that is because it can be directly billed to us, and we don't require mandated reporting on those forensic claims, which I'll get into detail with a little bit later. So for the application program, this is kind of the definition of the program. And each section that's underlined here, I will break down and go over going forward. But the intention of the program is to pay the out-of-pocket expenses or losses for victims of violent crimes who are innocent, otherwise eligible, and whose losses have not been reimbursed from another source. So we're going to go ahead and break that down a little bit. So
we have a question, Kelly.
Okay.
If you don't mind. We have someone in the chat asking, what is the max amount for what is the max amount a hospital receives for an exam?
So the maximum amount the hospital receives is $750. That's the negotiated maximum rate, and they write off the balance of that. So, and I'll go into that a little bit more in detail as we go forward as well. So the covered crimes that we have are outlined in statute and are listed here. Everything from murder, manslaughter, sexual assault, armed robbery, trafficking, child sexual and physical abuse, stalking, terrorizing, and some OUIs and hit and runs. Those are normally, we generally do not cover vehicular crimes, but these particular ones tend to rise to the level of criminal negligence or reckless conduct, which we would at that point consider a violent crime. Things that are not covered: generic traffic accidents are not covered. Theft crimes and other property crimes are not covered. That's because these are often covered through insurance, civil suits, or restitution. Now you can see that there's an asterisk next to property crimes, and that's because there was recently a bill that went through and was approved where in July of 2022, we will start covering property crimes. This will be a separate part of the program. It must be self-sustaining and it must not take any funds from violent crime victims. So that's kind of nothing that you have to really worry about or think about right now. That won't even be implemented for another 1.5 years. And from at that point, there'll be more information on how we process those.
We have another quick question, if you don't mind. So maybe you'll be going over this, but does the crime have to have occurred in Maine in order to be eligible?
Yes and no. So for the application side of the program, yes, the crime has to have happened in Maine. The person does not need to be a resident of Maine, and they do not need to be getting any other treatment or anything like that in Maine. It's just whether the crime happened in Maine. So we see a lot in the summertime when people come for vacation that they may be here and get assaulted, and then they go back home and need to be able to get any kind of treatments and assistance that they need where they live. So that is something that we would cover completely. For the forensic examinations, the examination just has to happen in Maine for us to be able to pay it. So that often is blurred a little bit, most commonly on the Maine-New Hampshire border. So for instance, somebody could be working in New Hampshire and perhaps be sexually assaulted there and then come back to their home in Maine and get treatment or their forensic examination at a Maine medical facility. We would cover that because we just cover all of the sexual assault forensic examinations that happen in Maine. So some of the benefits, most of the benefits we'll go over. So each claim has a $15,000 maximum payout. And to break that down a little bit, for example, if there is a victimization where the family members or household members also want to receive counseling because of their vicarious trauma, that would be included all under that same $15,000 pot of money. If we have somebody that has perhaps been a victim of a violent crime last year and a victim of a violent crime this year, those are two different claims, two different crimes. And so those would be two separate pots of $15,000. And we would do our best to attribute the bills to the respective claim. Medical expenses we cover at 75%. That includes facilities, ambulances, prosthetic devices, glasses, prescriptions, all of that. Alma works very hard to work with the medical facilities to encourage them to write off the balance of that after the 75%. And that way the claimant themselves is not responsible for as much of their medical bills. Dental expenses we cover at 100%. We also cover therapy and prescriptions, both for the primary victim and for ancillary victims. So again, this is a situation where perhaps if there is a victim who is has been sexually abused as a child and their family members, parents need to also receive counseling to deal with this, they would be eligible for that. And again, that's all under that same $15,000 maximum benefit. So with a situation like that, we do monitor it very closely to make sure that the actual primary victim is receiving the bulk of the treatment that's needed. We have had situations where family members and their needs will end up kind of using up the allotted or the maximum claim benefit. So what we try to do is work with the claimant as much as possible to really encourage that they are the primary victim and make sure that they have the funds needed for themselves to be able to heal as well. So that's just kind of a thing that we're aware of in processing these and making sure that we're really communicating with the family. So. Additional benefits. So we do cover lost wages and support. So this comes into play. Lost wages is only available to the primary victim. So if they lose time from work because of the crime that happened to them and any treatment that they need, we can reimburse them for those lost wages, as well as if the primary victim is a victim of a homicide and they were the financial support for minors, we do try to assist with that as well. We also do have something called dependent care. This is for secondary victims, so such as a mom that may need to take time off from work to help the child that was the victim or get them to treatment or etc. So we do cover that. That's a maximum of a $1,000 benefit, and that's up to $50 a day. So that's kind of detailed, and I'm always happy to explain that a little bit more if that's something that folks are running into.
We do have a couple questions, actually.
Okay.
So the first question is, can it be negotiated for therapy to be paid directly to the provider so that the victim, if uninsured, does not have to pay upfront?
Absolutely, yes. So that's generally what we'll do. If somebody is seeking counseling, if they already have a therapist, we can work with that therapist. And once it's approved by the board, the therapist can direct bill us. So, but what we require is that the therapist fill out a treatment plan for us. And that says basically, this is the estimated amount of sessions. It's X amount of dollars per session. And these are the crime related issues. So PTSD or anxiety or depression, any of those things that they're working on that are related to the crime, we can cover. So if they're already working with a therapist, generally they have that established relationship, we can either reimburse them for things that they've already paid out of pocket. So if they were, maybe a year after the incident applied to us, but had been going to therapy all along and paying that out of pocket, we could reimburse them for that. And then if going forward, we can use that treatment plan to calculate an award. So if the therapist says, we want to do 10 sessions at $100 per session, then we can make an award for the $1,000, and then the therapist can direct bill us that up to the amount of that award. And then if they need continued care, we would just get that treatment plan from the therapist again with their new estimation of the treatment plan and go from there. So we can both bill it directly to the provider, reimburse for any out-of-pocket bills that they've already paid, and make it a new award if they haven't seen anybody yet at all.
Awesome.
Additional questions from that one?
Yeah, there are two other questions. So there's, what if the medical and dental expenses exceed the $15,000?
So it's the $15,000 maximum benefit. So if those bills exceed that, we can pay up to that $15,000. In a situation like that, I would want to have a conversation with the claimant. Specifically, like if they're an adult, we can check in with them and say, hey, we know that you are seeking treatment and therapy, et cetera, for this. And then you've also got this medical bill that's like $50,000. Would you prefer us to pay out on the out-of-pocket expenses that you've already paid, such as lost wages, prescriptions, any bills they've paid, so that money goes directly back to the claimant? Or would you rather us pay the medical? And usually what happens is we end up paying that money for anything that the claimant has already lost out of pocket, because that's going to help them a lot more than a big hospital getting their bills paid, basically. If somebody's been out of work for months and they're barely getting groceries, and we can reimburse them for all those lost wages, even $15,000 of lost wages, that's usually what we'll end up doing, because that is more likely to make that person whole again than if we pay their medical bill.
Yeah, we have one last question, which is, do you have to be a citizen to be eligible for the program?
No, not at all. And I usually go over that in a little bit, but I will say, because that question came up, we do not require citizenship status in order to be able to work with a claimant. And that is one of the considerations that we would have in waiving that mandated reporting requirement to law enforcement or prosecution, because that would be a safety issue for that person. So.
I think we're set now.
I'll go ahead and continue on with this. So funeral expenses, we do cover up to $4,500, and burial monuments up to $500. And we do have something called a homicide benefit, which allows for up to $1,000 of expenses that are abnormal that are also related to homicide costs. So for example, a family member needing to fly here to be able to plan the funeral or identify a body, any of that, we can help pay for their airfare. We have paid to have a deceased body sent to their home country where they actually lived when they were here on vacation. So that's kind of what that is set there for. It's not for like catering or floral arrangements or anything like that. It's really for those extra costs that add a burden to the family, just for them to be able to come and do the basics of planning a funeral or getting here or any of that. So that is available, but it is something that we kind of look into as far as what that's being used for and what its intention is. We also offer up to $1,000 for crime scene cleanup. Now this is cleanup of biohazard waste, and so, but not replacement of any damaged stuff. So for example, if there's blood on a couch, they can come and clean the couch, but they cannot replace the couch because that's under that property damage aspect of that. We also offer repair and replacement of locks and security devices up to $1,000. This also includes doors and windows if those are damaged as part of an assault. And this is not for a, not necessarily like a one-to-one replacement. So it can be increased security devices as well, such as adding cameras where there were none before, or a keypad lock instead of a key lock. So we do offer that, and that's up to $1,000. And in the last several years, we've also been able to offer security deposit reimbursement. Because we're not an emergency or urgent need program, it's generally hard for us to be able to get security deposit funds to a claimant in enough time for them to be able to be safe. So what we have is memorandums of understanding with the domestic violence agencies, and we've also extended that to the sexual assault agencies, that if there is a safety issue and somebody needs to be relocated and the agency is willing to pay the security deposit, we can put that in as a reimbursement for the board to consider. The understanding is that if the claim itself is not approved and does not qualify, then we can't reimburse that back to the agency. And I know that that is a concern when considering whether to pay it, whether the agency can kind of foot that bill if it's not approved for reimbursement. So generally, a lot of the agencies will just call me and have a conversation with me, and I can give them an idea of whether it looks like the claim would be approved or not. Again, it's not a guarantee, but it is how we try to work with folks to make sure that you guys have confidence in being able to assist the claimants that you're working with.
We have a quick question about the locks and security devices.
Yeah.
Do they need to buy new locks and send receipts, or will you take an estimate for those?
So we do both. If they're able to do an estimate, so for example, if they're using a professional that can do an estimate and send that to us, then we can make an award for that. And once the bill comes in, we can pay that out. We've also been able to reimburse them if they've bought things out of pocket. So sometimes we've seen people will buy their own locks and security devices either off Amazon or from Home Depot or things like that. So if they provide the receipts, we can reimburse them. But outside of that, if they aren't able to provide an estimate, then they would have to pay buy it in themselves, and then we can reimburse them for that. So ineligible expenses, these include stolen or damaged property. And as I said earlier, we will look at a property crimes change next year. And I will probably schedule a full presentation or a couple full presentations just to go over the details of that when it becomes applicable. We also don't cover pain and suffering. Those are not out-of-pocket expenses that we can cover. The sexual assault examinations are not covered through this side of the program. They are covered through the other side of the program. That's why we have it here, that actual forensic examination doesn't need to be applied for. And we do not cover expenses and losses that are not related to the crime. So compensation does not equal a criminal case. We are separate from the court system. The AG's office, we're housed within the AG's office, but separate to where they're not weighing in on our cases and that kind of situation. So what that means is that we don't need a beyond reasonable doubt amount of evidence to be able to approve a claim. We use a preponderance standard, which just means that it's more likely than not that this happened the way that the victim is claiming that it happened, and we can approve that. We can also approve claims even when prosecution is declined or there's no suspect. Sometimes that happens when there's simply not enough evidence for them to go forward with, or they're not sure who the suspect is. So we can approve even in those cases. But the application side of the program does require mandated reporting to law enforcement and cooperation with prosecution. There is an exception to that. The board has the discretion to waive this requirement for good cause, and that generally happens when there's a safety issue or concern. So domestic violence, sexual assault, stalking, if there's these safety concerns where reporting to law enforcement would endanger the victim, we would absolutely not want that to happen and would waive that. This is also where we would use a good cause is to waive for immigrants and folks who are undocumented, recognizing that mandating that they go to law enforcement could put their life in jeopardy, basically. So that is something that we would consider as a good cause for waiving as well. So for eligibility requirements, the people who can be eligible victims are the actual victim of the covered crime, which is the statutory list I provided earlier in the presentation. That is the person who is actually injured, whether it's a bodily injury or psychological injury. We can also cover a family or household member of the main victim, and they are only eligible for certain benefits and for certain crimes. So counseling, they'd be eligible for, and stuff like lost wages. They would not be eligible for lost wages because they're not the primary victim. And then we can also pay the person who contracts to pay the bills for a victim. So for example, the victim themselves cannot pay their own funeral bills. We would reimburse whoever it is that did pay those funeral bills. So we also have the statutory requirement with contributory conduct. And what that means is that a person who causes or contributes to their own injury because they're committing a crime would likely be denied for their application. Now I say likely because it used to be that we had to decline or deny those applications. The board now has discretion to approve in part or in whole reimbursement to families of homicide victims. So if there is a death and the family pays the funeral bill, the board has the discretion to determine whether they will reimburse the family or not. And usually the line that we are sitting on is whether it was a violent crime that happened or not. So if this person was murdered in the act of creating or committing a violent crime to somebody else, it would be unlikely to be approved. If it was that they were killed while committing a non-violent crime, there's a possibility of approval. And something like that might be like purchasing drugs. That's not a violent crime. They shouldn't have to reasonably expect that they would be murdered in doing so. So there is a possibility that we can reimburse those funeral costs for those situations. Now, I also do want to clarify here that when we talk about contributory conduct, I usually get questions about folks who are trafficked, and we do not consider them to be committing criminal conduct. They are already victimized before they have committed any kind of crime. And so we see victims of sex trafficking as victims first and foremost. So that is one point I did want to clarify, because I generally get a lot of questions about that one. So in reporting cooperation, we do require that report to law enforcement and that it be a timely report. So 5-day reporting period, we will generally give some wiggle room on that, especially if there's an extenuating circumstance, but just a reasonable amount of time, if it's a week, if it's within a month, whatnot. And again, that's waived for good cause for adults. So if there's a safety issue, if the person is still cohabitating with their abuser, these are all reasons why we might waive that because it's a safety issue. Also, this required reporting is always waived for minors. Minors are not in control of their ability to report or cooperate with police and prosecution. Often the people who have victimized them and abused them actually are family members who would be in control of whether they could do that or not. So we waive that requirement for minors, both with the reporting of law enforcement and with the application being within 3 years of the crime. And we also require that the applicant cooperate with the board and reasonable requests of law enforcement and prosecutors, but specifically with the board, because we do request the supporting documentation in order to be able to verify what has happened to them. So if we're asking for lost wages and need them to provide us with pay stubs, stuff like that, we would need that cooperation in order to be able to have the board approve a claim. And then we also do require that the application be filed with the program within 3 years of the crime. Again, this is waivable for minors and can be waivable for adults, again, depending on that good cause situation. And then with minors, it's also a situation of if they are now adults, but were victimized as minors and perhaps are now getting treatment to deal with that, that time period is also waived because they were minors when the crime happened.
Kelly, we have a quick question. The question is, what about if a victim kills themselves as a result of what happens to them, like in an assault? Would the families be eligible then?
That is a really good question. We have not had that come up yet, thankfully. So I don't have an answer because there's no precedence for that, other than in statute, if we technically adhered to the letter of the statute, probably not, because the violent crime is not, it's so weird because I can definitely see the domino effect there. And as somebody who's been an advocate, like totally make that connection and think it's very reasonable. I don't know if statute would support that. And so I don't have an actual answer for you on that, unfortunately. And it's probably something that we wouldn't know until it came up and we had precedent for the board to make a determination on that. I think that if we could clearly show a history of like either with their medical or counseling treatment, suicidal ideation that is specifically linked to the crime, it's possible. And I think I could make an argument for it, but I just can't give you 100% answer, unfortunately. But that is a great question. And I think doing these presentations, I get a lot of questions like that. Like you all have such great thought processes. And it's definitely information that I take away in order to make the program more trauma informed and victim centered with whatever changes that we can make. So one of the aspects of the program is that we are a payee of last resort, which means that we cannot pay out until they have utilized their other resources. So if they have insurance, it goes to insurance first. We can pay copays, deductibles, prescriptions, or any bit that the insurance will not pay. If there's charity care, this is also called free care through the hospitals in Maine. And so they can write off or release some of those medical bills for victims that need financial assistance. Workers' compensation is also something like that as well. So basically all these other resources must be exhausted first, and then we can cover them. One exception is that we do not require folks to use in-network providers if they do have insurance. So if therapist number one is covered by their insurance and is like a $10 copay, and therapist number two is not covered and it's like $150 per session, but the victim says, no, I really need this other therapist that's not covered by my insurance, and this works better for me, and et cetera, whatever reason, we don't require them to use the in-network one. So if they choose to use one that their insurance does not cover, we would pay that full amount that's not covered. But it's not ethical for us to force victims to get their services from one or another provider. We do not offer recommendations for specific providers because as a state entity, we do not want to run into the ethical situation of choosing who people use and then paying those providers. So whatever the person chooses as the best form of treatment for themselves, and as long as it's licensed and crime related, we can cover that. And then there are also cases where folks are awarded restitution or civil suit settlement proceeds. So if they have already had those things before they apply to us, and those things should have paid for those bills, we can't do those bills. If we pay out bills for a claimant and then they get restitution, they do agree in the application that they will reimburse us. So that way they're not being double paid for the same bills, basically.
We have another question.
Yep.
If a victim applies and you have to mail them, will that have the victim compensation program address, or is it blank?
You mean like regular postal mail?
I believe that's what this person's saying.
So yes, generally, we do have to use the specific programmatic mailing documents, but we will send them to whatever address is given to us. So if the person does not want it going to a specific address, so for example, we've had issues or situations where they didn't want it going to a parent because they didn't want the parent to know that they'd been sexually assaulted at college or something like that, they can provide us a different address. And then there is also the address confidentiality program, where they can get an address that a perpetrator cannot track them to. So those are some options for that. We could also we haven't done this before, but just as I'm thinking about it, if any of the agencies want to offer to be the mailing address for a victim, they could do that. We would not just do that though without confirming with the agency that you're willing to do that on behalf of a victim. So our funding sources, there's generally some misconception about this. Because we are run through the state, folks tend to think that we're also funded by the state, that we're part of the state spending budget and the general fund. We're not at all. We actually receive no tax dollars and no general fund funding. All of our funding comes from fines and fees that are assessed to perpetrators and offenders, and from restitution or settlement proceeds that are reimbursed to us. So this can have a palliative effect when you're working with a claimant that they don't want to, quote unquote, be a burden on taxpayers. That's not the case. And telling them that, no, like you're actually, this program is completely funded by these criminals, these perpetrators and offenders, can be a really big part, a surprisingly big part of their comfort in working with us and moving forward with that. So in Maine, we are funded $25 is paid for every class A and B crime, and CDE is $15. So those are where the funds from the state come from. And then it's the same thing on the federal level for federal crimes. And that's where the VOCA funds come from that we get a grant from every year that we have to apply, and it's based on our spending and such. So regardless of whether it's state or federal, it's all offender funded. And then again, if there's restitution or subrogation, which is when we negotiate with the lawyers to take a lesser amount than what we paid out, that does come back to us if those things are awarded. So this is the process for how we do our claims. It starts with the application. When the application comes in, we start soliciting the supporting documentation that's needed from law enforcement, medical records, therapy, employment information for lost wages, etc. We try to do all of that ourselves so that the victim themselves does not have to take on that burden. And so we work really hard to directly connect with all those resources to get that information. If that information is not forthcoming from those resources, we will loop in the claimant so that they understand what's going on and can perhaps assist with that. So perhaps it's an employer who is reticent to give us employment documentation. The claimant can go to their HR or boss and say, hey, we really need to fill this form out. So we do include them after we've already tried to solicit that information, but we want to try to unburden them as much as possible. Once we have all that document verification, I review it, I make sure that everything is there, and whether it is or isn't there, and I make a recommendation to the board based on statutory requirements as to whether they should approve or deny it. And then every month the board meets, and so at the board meeting, they will make a determination for the claim. We do have board member requirements. We have 3 board members. They need to be 1 medical professional licensed in the state of Maine, 1 law professional licensed in the state of Maine, and 1 victim services professional, whether that's current or prior experience with victim services. Currently, Tessa Mosier, who works at DOC, is our victim services board member. And again, we meet once a month to do that. So if the claim is approved, then we just process it. We send out the letter to let the claimant know that it's been approved. And then we also send out the checks, whether it's to them specifically or their providers. However, that's been determined that those need to be reimbursed. If the claim is denied, they do have a right to request a hearing. They can do that within 30 days of receiving their denial notification, and we will schedule that for the next available board meeting. And at that board meeting, they are able to meet with the board members. Currently, we're doing it all virtually. and they can kind of provide any additional evidence or information that they think that we need in order to make a different determination. After that, the board will deliberate and notify them. We'll notify them again via mail after that. At that point, if it's approved, great, we just process it the same way we do first approvals. If it's denied, the claimant does then have the right to appeal to the Superior Court of Maine and have a judge make the final determination on the case. That has only happened 3 times in the history of the program, and not since I've been with the program, but that is there, it is an option. So at that point, it would no longer be up to the board to make that decision. A Superior Court judge would do that. So the programmatic goals are to make sure that we can reach all eligible crime victims in the state of Maine. That's a big reason for doing a lot of the outreach that we try to do, is to make sure that as many advocates, law enforcement, victim witness advocates, DAs know about the program. And that way, when somebody is going through a trauma of having been victimized, they're getting this information along the way, and that seed is being planted that this is a program that they may be eligible for. Without that, I think a lot of that information gets kind of lost and forgotten in the space of being in trauma, and it's really difficult for people to remember all the recommendations that were made to them. So having as many people as possible that a claimant comes into contact with know about the program is very, very helpful. We try to process all the claims with speed and efficiency. Our claims processing is very, very dependent on how quickly we can get supporting documentation back. So sometimes that's very quick and we can literally process it and put it to the board for the very next board meeting. More often than not, it's a slight delay in getting that. And especially if medical records have been outsourced to places outside of Maine, it can take us a lot of time to get all that stuff back. Also, if there's a homicide and it's an open investigation, it can take us some time to get the report for that. And then we also aim to provide the maximum benefit within statutory limits. So statutes are very kind of umbrella. They kind of, cover over everything in a very broad way. This allows us some space to try to interpret the statute with more trauma-informed, scopes and be able to kind of assist a lot better. So for things like medical bills, we've been able to cover under that a service dog, because that is part of what their requirement is medically and for mental health wise. We've been able to approve for minors horse therapy and EMDR and more progressive forms of therapy that are not so traditional. And we try to maintain that kind of wiggle room where we are adhering to the statutory limit, but we're also trying our best to do as much for the claimant as possible. We are stewards of this fund, which means that we are tasked with making sure that it is spent ethically and responsibly, and that it is also spent legally. So there's a lot of statutes that we have to adhere to and a lot of requirements that we have to agree to in order to receive grant funds and such. So that is our goal, is to make sure that we are completely in compliance at all times. And then to treat the claimants with dignity and compassion and fairness. We try to be very open and communicative about the likelihood of, hey, maybe this claim, this particular bill definitely seems like something we can cover. This other one, I'm not really sure, but we can definitely put it to the board to find out. So we try to be very transparent about that. And in coming from an advocacy background, I've really tried to make this program much more of a victim services program, more than just a government kind of bureaucratic program. Again, we are limited by what statute says, and statutes take so long to change and progress and move forward. So we try to work as best as we can within the scope of what we're allowed to do. Roles of allied professionals, this is all of you. So what's really helpful for us is to have as many of our allied professionals knowledgeable of the program and able to make referrals to us, helping victims be able to do the application. The application is very simple, but when people are traumatized, it becomes much more difficult for them to be able to sometimes understand all of that. So if you can assist them with the applications, that's fantastic. And if you can make those referrals, that's great as well. And then if we're requesting any forms or records or bills, this is not so much happens with like MECASA and MCEDV, but more with like medical records and counseling. But if we do request something from you, the quicker you can get it to us, the quicker we can turn over their case and get it in front of the board. And then you are always welcome to call or email with any questions. I would much rather have a conversation about the likelihood of a claim being approved or denied than for you to make that determination and say, no, don't bother filling out an application or whatnot. So I would rather us have that conversation and me to be able to give you a little bit more of an idea of what we can or can't cover, or if you come across a sticky situation or something that you don't have a lot of experience with that particularly happening, please do reach out. Okay, so I'm going to take a deep breath before we go into the forensic examinations and just see if there are any other questions or concerns or anything you want to discuss real quick. Okay. All right, so I'm going to move on into this. So we consider the forensic examination part of the program completely separate because it has separate requirements, separate procedures and processes. And so that's why I kind of deliver this information in kind of two sections. So I can break that down a little bit more. So this was implemented in Maine in 2000. And the entire purpose of having this done is to make sure that victims are not paying for their own evidence collection. So prior to this, sexual assaults were the only crimes where victims actually had to pay for their own evidence collection. You wouldn't have to do that if it was a regular assault or a burglary or anything like that. So it became a really big issue where there was no responsibility, or the responsibilities on who paid for these things was very mixed and unclear. A lot of the times the victims were being billed to their insurance or having to pay out of pocket. If they knew that they couldn't afford that, they would just forego having this evidence collection done at all, and therefore not receiving any medical treatment as well. So this really came into play because we needed nationally kind of a cohesive way of dealing with these forensic examinations to ensure that we were trying to take care of victims as best as possible. So I'm going to go over a couple different parts here about the payment process and the kits and such. And if there are questions, again, please let me know as you go through. So the standardized kit comes from the Department of Public Safety. They create it, they disseminate it. It is a uniform standardized kit, and it is required that all the whole state of Maine, all these forensic examinations use this one kit. This is particularly good because it means that we have a cohesive kind of batch of evidence when it goes and is examined. So that makes it so that there's no concerns around prosecution that perhaps they had used a non-standardized kit or a tampered kit or any of that. Bills come to us directly. The hospitals will direct bill us. It comes to us anonymously. We don't know who the person is. We just pay it. If the person has reported the sexual assault to the police, the kit will then go to the investigating police department. to be stored or given to prosecute the crime lab in order to be included in prosecution. If they decide not to report it, which they're not required to do, then it would just be stored at the nearest police department. And then the hospital will provide the patient with that kit tracking number and the agency that's holding the kit in case the victim then decides that they want to report after the fact. So again, DPS, they develop the kit contents, instructions, and checklists. And then the hospitals get the standardized kit from the state warehouse. The forensic examiner must use these kits and be trained in the proper evidence collection procedures for these. This training happens twice a year. We co-fund this training, as well as I will present at this training and kind of go over this entire presentation with them. So these nurse examiners know more about the program and how we get billed for these forensic examinations. This goes over a bit of what we can cover in the forensic examination. So the broad strokes is that we can cover what is related to forensic evidence collection and the immediate medical necessity as part of that forensic collection. We can't cover additional medical bills that come either after that examination or that are separate from that examination unless they want to apply to the other side of the program. So here, this kind of gives you a rundown of the list of what we cover in those examinations. And it's the basic medical treatment, any room fees that they have, labs, STI and STD testing and prophylaxis, pregnancy testing and pregnancy prophylaxis at that point. And then they can also be given sedatives, tranquilizers, antiemetics, any medications needed immediately for that forensic examination. And if those medications and prophylaxis are offered at the facility, that's what we can cover. If they are given a prescription for something and then sent to their own pharmacy, that's after the forensic examination. We wouldn't be able to directly pay for that. That has to be applied to from the other side of the program. So again, this just kind of summarizes that for the purposes of reimbursement, it's all the services that are directly related to evidence collection and initial testing and treatment, that they must use that uniform standardized forensic kit to be able to bill that to us, and also just to ensure that the claimant is being treated fairly and that there's no risk in jeopardizing the evidence by using something that's not a standardized kit. And that if there are additional medical expenses, we can reimburse those, but it has to go through that application side of the program. So I'm going to give a couple examples. So if a person is sexually assaulted and during that sexual assault, they receive a broken arm and they go and get a forensic examination done, we can cover all the forensic examination. We can't cover the broken arm because that's not part of forensic collection. They would have to apply to the other side of the program for us to cover that. So that's kind of where that separation is. That also happens sometimes with strangulations that happen during the course of a sexual assault, where the victim then needs maybe a CT scan or additional treatment. Again, because it's not part of forensic evidence or collection of evidence, that's considered a separate medical bill. This is something that I hope in the future that we will be able to change, especially around strangulation, because that is such a serious thing that really shouldn't be messed around with as far as what can be covered or not. And ideally, we'd also like to see mental health treatment be able to be included without having to go through the application side of the program. So those are goals, but statute and statutory changes are very, very slow and somewhat difficult. So at this point, it's fairly limited in the scope of what we can cover for the forensic examination. But again, anything that's not covered in that forensic examination, they can apply to the other side of the program. That does change the requirements as far as mandated reporting. But again, if there's a good cause exemption, we could do that. But please don't rule out that somebody can get mental health or lost wages or other medical expenses covered just because it's not covered directly through this part of the program. Please do refer them to the other side, and we can go from there.
Kelly, we have a quick question on in the chat. If there is not a SAFE or an SIT available and another medical provider does the kit, is the hospital still reimbursed?
Yes. So that's one of the kind of problematic issues of Maine. There are simply not enough sexual assault nurse examiners. They are not compensated fairly. They are often burnt out on this. And because there's so few and Maine is so large, sometimes these forensic examinations happen when there is no nurse examiner available to do it. And that's just the reality. That is contrary to the statutory requirements, but the worst, it's the lesser of two evils as far as if there's no sane nurse, do we not do a forensic examination for this victim? So having it done by other medical professionals, if there is no sexual assault nurse examiner available, is what happens basically. Again, they are still using the same kits. It's still the same standardized evidence collection. And the instructions in the kit, if you follow them specifically, kind of to the letter, you can actually, it outlines everything that you need to do and the way you need to do it. So that's basically what medical providers are using if they're not trained in this forensic examination techniques. And again, they do this training twice a year, but it just kind of seems like there's just really never enough nurses available to really be able to hold up the entirety of the state's need. And then they are trained that they are supposed to call a sexual assault advocate or response team to be able to be there and support the victim. Sometimes that might not happen either because there might not be a sexual assault advocate near or able to come. And that happens a lot more in our like northern and western counties where things are just so spread thin. So that's kind of what happens. DHHS is the other half of providing this training, and the position that organizes all of that training. They're trying really hard to make sure that there are enough nurse examiners, but it's just kind of an uphill battle in Maine, unfortunately. So again, if the crime is reported, the investigating agency transports the kit to the crime lab. This slide actually has an error on it because it's no longer 90 days that the agency stores the kit for, it's 8 years. And I just realized that I hadn't updated that. So where before the nearest agency would store the kit for 90 days if there was no report, now it is stored for 8 years, and that allows for later reporting if the victim chooses to do so, and that the kit is not thrown away after 90 days, which is often not enough time for the healing necessary if a claimant does want to report to law enforcement and then have their kit put in as evidence. And then the big important part is to make sure to enter the police department on the claim form to us. That way we know where it is stored. This goes over a little bit of the claim form. This is fairly brief as y'all aren't really filling this out. This would be the nurse examiner staff that would do this. So the form needed to bill us is inside the kit. So they'll get that form and they open the kit. Sections 1, 2, 3, and 5 will be completed by the emergency department staff, and section 4 is the billing office, and that's where they will itemize and send us the bills. So again, we are negotiated to pay a maximum of $750 per forensic examination. The bills are generally in excess of that, sometimes quite substantially, depending on how much treatment the victim would need at the hospital. However, the negotiation is that we pay that $750 to the medical facility and that they write off the rest of that. They are not allowed to bill that balance to the claimant or to the claimant's insurance. If they do so, they are in violation of national statute and law. And if you see that happen, please do immediately reach out to me so that I can follow up on this and make sure that they are in compliance, because they can lose their federal funding if they bill a victim for their own forensic examination. Let's see. And then again, the billing department is going to code that, and the providers, it's generally a sane nurse and a doctor will sign off on the form. Section 1 of the form looks like this. It's basically the kit tracking number. Each kit has several of these kit tracking stickers in it. So those will be used to label all the evidence outside of the box and also the form that comes to us. The kit tracking number is the only way for us generally, or anybody else, to be able to track that kit, because it is completely anonymous, and that is the right of the victim for this to be completely anonymous, so that they don't have to report to law enforcement or anything like that if they don't want to. This is section 2. This is where the emergency staff will give a brief description of the exam and what treatments and tests that they did. They'll sign off on it. If it's a nurse examiner, they will put here what year they completed their training and their name and information, and then the other contact information for whoever in the emergency department did this examination. Section 3, this is where they'll notate the law enforcement agency and the investigating officer if it's reported to law enforcement, and if it's not, this will be kind of left empty. So this says, was a law enforcement report made and when, and then also the town and city and county of the crime, and that's because that's for jurisdictional issues. Section 5 is just the clinician's information, so they'll put all that in and whatever billable charges that they want to bill as well. And then section 4 is the billing part of the form. So this is where everything's coded, and they will note down all the different testing and treatment that was done, and that's what gets sent to us. That we can input into our system and calculate out the bill, and then just send them the $750. And then this is, again, there's the roles and the roles of advocates and hospital staff. So having some information about this program and the forensic protocol, being able to make referrals. Every kit does have one of our applications inside of it. So if there are additional medical bills or they want to have counseling or any of that, the application is given to them so that they can do that. And if you are, as an advocate, working with them, you can also inform them of that and help them with that referral. And we require that staff complete the forms per the instructions on them, and that they file that bill to us within 60 days for compensation. And then this screen is to really just highlight the difference between the two sections of this program. So as you can see on the application side, we can cover all violent crime victims, but on the sexual assault forensic examination side, it's just limited to sexual assaults. On the application side, there's numerous benefits, again, medical, counseling, lost wages, homicide benefits. On the forensic exam side, it's limited to that evidence collection. Application side requires an application, whereas the safe side direct bills to us. The application side has eligibility requirements, whereas the safe side does not have a reporting or other eligibility requirements. It's direct billed immediately. on the application side, we're a payee of last resort, whereas over here, we are direct billed, we're the first and only payer for that. And the application requires that the crime have happened in Maine, whereas the safe side requires that the exam have happened in Maine. All right, so just final thoughts. We rely a lot on advocates and community partners within the state to help get this information to the victims that they're working with, to help advocate on behalf of them, and to give them some just very basic support and information. And that's really important. The majority of the applications that we get are from advocates from the resource centers and advocates within the DA's office. So it's really important that in doing outreach, we want to make sure that as many people know about this as possible so that they are able to help support victims in getting some compensation. So, all right, questions, concerns? It's a lot of information, I know. I'm not seeing anybody.
I think you answered a lot of great questions along the way. Like, I'm very impressed with the conversation and engaging. It was really fun to hear the conversation. So thank you for that.
Yeah, absolutely. I love doing these because I think that advocates are so much more in touch with what claimants need. They're boots on the ground. They're doing it every day. So the questions that you guys ask are really thought-provoking, and sometimes are situations that we haven't even experienced or encountered yet. Again, the question about potential suicide. I've had the same question about if with a sexual assault, somebody became pregnant and then wanted an abortion, and would that be a medical bill that we could cover, and et cetera. So these are like really great questions that come up out of these, which is why I like doing them so much. Definitely not because I like the sound of my own voice.
Well, we really enjoyed your presentation. There's been many thanks in the chat for you. And I know it was super informative, and thank you for all of the amazing work you do on behalf of victims. We're so glad to have your partnership. So thank you so much for your time. And everyone, if you could just look in the chat real quick, there's the survey that you can fill out and send along to Kelly or me. And I hope that you all have a wonderful rest of your evening. Thanks for being here.
Thank you all so much. I'm sorry I took a little extra of your time, but thank you so much for being here today and listening. And let me know if you have any questions.
Thank you, Kelly.